how the police did this investigation, and it's preposterous because all this is a lie. Everything Mr. Copeland said is a lie, yet they're using him as a primary witness against Mr. Williams and others. Detective Dennis said, and I quote, "You are the prime suspect, but pull yourself out of the equation."
Investigator Dennis seems to be very interested if Mr. Jeffrey Williams is gay. It leads to Mr. Copeland explaining that Mr. Williams is not gay.
Day 95 of the Young Thug YSL RICO trial was tedious. The state attorneys and defense lawyers argue over what part of the Woody interviews will be shown to the jury. There's a funny part in today's video where the state tries to cite a case that Brian Steele was actually a part of and it didn't apply whatsoever. And for some reason, a lot of talk about Birdman and Thug's sexuality. I don't know why the detectives were so pressed on this with these interviews with Woody. Hit subscribe, here we go. First look at Thug on day 95. Got the hair down, brown button-up shirt on. Brian Steele's showing him something on his phone right now.
So if you was gay, who you think killed that?
Who do you think killed Nut?
You prime suspect, but move yourself out the equation. Who you think did?
I'm about to switch that.
I'm just saying, like, word on the street is, basically you've been tried and convicted within the street there.
Now they said, two of my work partners, well, not so good, but
Who?
I think it's your name. Cause I didn't like mix. I think you got something to do with them. I think they did something. Cause I've been hearing stories like Nut supposed to ran off on somebody with something, but they did it on the code. All these on him because I'm with Thug and Birdman, and they come back to them.
Nut ran off with someone's shit. That's what the state doesn't want the jury to hear.
He got 25,000 here, fake kill.
Who did?
The rich on corn shit.
25,000 to kill someone again.
He's hearing stories like Nut's supposed to ran off on somebody with some jewelry.
Max SCHARDT responding.
Kenneth Copeland talks about Thug's sister saying that Bloody J said that Thug is gay. Speaking for myself, and I believe I'm speaking for everyone else, but I don't think that we have a problem with redacting that. That would be hearsay. A section that talks about what do you think happened, or if you were to guess, what would you say happened? Mr. Copeland gives various theories, head and doc, and then talks about a theory of that he heard from other people. I concede that he heard it from other people. That Nut ran off. It sounds like he's talking about drugs, ran off on someone and got himself in trouble. The reason that this is important, it's not for the truth of the matter asserted, as hearsay would be. It's important because the state's theory in this case is that on January 10th, 2015, late at night, Kenneth Copeland went and picked up Demekion Garland at the McDonald's on Cleveland Avenue. And Demekion Garlington told Kenneth Copeland that it was Shannon Stillwell and Demonte Kendrick, Justin Cobb, and Demise McMullen in this car that did the shooting. So according to the state's theory, on January 10th, 2015, Mr. Copeland has that knowledge on that date. This interview is 18 days later. Presumably, if that were true, that Kenneth Copeland was given that information on January 10th, Investigator Dennis says, Mr. Copeland, what do you think happened? Presumably, if he was given that information on January 10th, that is when he would say, this is what I think happened. I think Shannon Stillwell and Demonte Kendrick and Justin Cobb and Demise McMullen were in a car and they shot Donovan Thomas. Kenneth Copeland did not answer it that way. Instead, he said, well, Doc and Head, they may have done it, but I really don't think they did it. And I think it had something to do with Donovan Thomas running off with some money on, a bad deal. And that's what I've been hearing. So it's not for the truth of the matter asserted. It's impeachment of Kenneth Copeland to show that his story that he was told on January 10th is not accurate. I was given this information on January 10th. But on January 18th, when he's asked about it, he doesn't say it.
Okay, I see.
So that's the purpose of it. It's just like any other impeachment. You had an opportunity to say something and you didn't say it, and now you're saying it on a later date. And now the difference between January 28th and June 10th is on June 10th, all of a sudden Kenneth Copeland is facing 5 or so felony charges.
The difference is he's trying to say that it was because he was charged with shit.
All of a sudden he has this information.
And he could be lying just to get out of jail. I mean, that's a good point.
He's talking about an unrelated thing about Rich Homie QUAN supposedly putting $25,000 on the head of a gentleman named Tay. We agree that that's unrelated, and that, I don't know if that's hearsay or not, it's a little unclear, but it's unrelated.
The portion that we have an issue with, Your Honor, that we believe should not be played is the portion where specifically he's talking about Nut running off with some jewelry or some. First of all, Copeland never says anything about drugs. We don't even know what supposed rumor is, right? And so the state's contention is Mr. Copeland says, I heard it was about some jewelry or some drugs. He doesn't even know. And that is bad character evidence. There's a rumor out there that some other people may have done it, but, we heard that Nut may have stole some jewelry. That's not specifically talking about any specific person. That's him giving a theory based on a rumor that he heard.
If the defense on cross-examination lays the foundation, as Mr. SCHARDT said, he has knowledge that Mr. Copeland knew of this earlier. And And then on the interview in question, he's saying something that would be different. So if he had knowledge of it and he gave it, that would be impeachment. They know what he said later about what he knew earlier. So that's where the impeachment's coming in. They have a good faith basis to ask him about that. Mr. Sharp, I'm sorry to interrupt you and Mr. Steele, but is that kind of what you're trying to get at?
And if he had knowledge on January 10th,
Why didn't he say it on the 18th?
why didn't he say it on the 18th?
Okay.
I'm actually very surprised the judge is agreeing with this.
Hearing rumors that Nutt supposedly ran off with jewelry. That does not directly talk about who killed him. That is him speculating about what theories could have came in as to why he was killed, but it does not directly talk about who killed him.
Brian Steele wants to say something.
I don't agree that these statements get played at all again. So I know what you're doing, but it's over objection because I don't believe it's a prior and consistent statement.
Okay,
As I
so
said
you're
earlier.
disagreeing with Mr. Sharp about that. You're saying you don't want to play it at all.
Right,
Because
because
just so I'm clear about that. Okay.
And I raised this before because the testimony was I probably did. Most of the testimony is I don't remember, but I probably did say that because I was lying to the police. So this is not a prior inconsistent statement. He's saying I probably did say this. So I don't think any of this exercise is appropriate. You've ruled that portions may come in, and that's what we're doing. So
I just want to be clear that that's my stance as well about just playing videos. But
Okay.
based upon, don't tell me what was said, but based upon your investigation, what did you learn? Or what did you do from what you learned? And did you corroborate that? And I don't know. I have no idea where this information came from. And I've asked the court, and I said it's a confrontation clause issue. You've denied it. I have no reports on who they spoke to gather the information that they are now putting to the jury that YSL is a criminal street gang. This is a good example, and I want to play it for the jury, of how law enforcement gets their information. I want the jurors to be able to see that it's Detective, in this case, Gaither and Detective Dennis. It's the 28th day of January 2015. And they asked, what did you think? Who did you think killed Nutt? And then all this conversation flows from that question that the state is trying to keep out, that Mr. Thomas stole from someone else. And I'm not using it for bad character. Mr. Thomas' bad character is already in evidence. The state brought up that he is the head or leader of a criminal street gang. In addition to that, I disagree respectfully with Mr. SCHARDT. And I want the false allegation that was made that Rich Homie Quan put a contract to kill someone for $25,000 up front and then $50,000 thereafter, because it shows another person falsely accused by Mr. Copeland. And if you listen to the whole thing, I think it was cut off. Mr. Copeland says that he actually spoke with Rich Homie Quan to kind of be the intermediary.
So Brian Steele has other motives on why he would want this than Sharp. That's interesting.
And I'll make it clear to Mr. Copeland, I disagree that Rich Homie Quan, he's a gentleman. I disagree that he committed any type of offense, but this is the exact statement that Mr. Copeland levels against Mr. Williams, that Mr. Williams put a contract out on Mr. Copeland's life, which is untrue as well.
So Brian Steele's also trying to make Woody look like a liar.
And this is a perfect example to show how baseless the prosecution cases against Mr. Williams and the other, and how the detectives have not done a proper investigation. So that's why I wanted it. What do you think happened? Here it is, and I want the whole flow. How the police did this investigation, and it's preposterous because all this is a lie. Everything Mr. Copeland said is a lie. Yet they're using him as a primary witness against Mr. Williams and others.
Jeez. All right, so Steele has a plan. I wonder how the state responds to this.
If I'm comfortable with one killer.
Who knows if Woody's telling the truth? Like, the state's star witness is a known liar. What a disaster.
This $25,000, which has nothing to do with the issue at hand in this case, which is who killed Donovan Thomas.
No, not necessarily. If he's got another version of who may have done what, that's impeachment by contradiction, just straight out impeachment.
But this isn't a version of who killed Donovan Thomas. What they're talking about is who killed.
It doesn't make a difference. If he's telling materially different versions of what happened, that potentially is, he can be impeached on that.
Yeah, he can be impeached on that. He's spewing out shit that's not true.
What
happened or how he came to find this information. I mean, if he's given the police different versions of what may have happened.
When you say what may have happened, what he's talking about.
What he told them.
But when you say what may have happened, Your Honor, in this portion, he is not talking about the murder of Donovan Thomas. He is talking about Rich Homie Quan's father was shot at in September of 2014. In this particular portion, he is only talking about the fact that Rich Homie Quan thought that an individual named Tay shot Rich Homie Quan's father. This has nothing to do with the murder of Donovan Thomas. Okay. So this isn't him giving a version of facts as to the murder of Donovan Thomas.
This is Mr. Copeland, who is a huge witness, as the court knows, in this case. He is lying to law enforcement about Rich Homie Quan conducting a murder for hire. The state wants to say, well, that's irrelevant because it's a murder for hire of a different person, Tay, T-A-Y. My point is, that is the witness. It is a false allegation against another human being to do a murder for hire. The state doesn't get to limit the cross-examination to what they want it to be, and it goes to the investigation of detectives.
Each week, I'm baffled at how good of a lawyer Brian Steele is.
I had no idea when they say, based upon our investigation, we learned the following. We learned this. I still rely on my constitutional right to have that information, but I don't have it. And this is a prime example that they get garbage. That's my position. Mr. Copeland, they say it's absolutely true. The state was going to call Rich Homie Quan. His name's Mr. Lamar, L-A-M-A-R. I guess now they're not. I may call Mr. Rich Homie Quan after it comes out that, if I need to, that he put a killing on someone else. Mr. Copeland may say, yeah, I was lying to the police, which I have a good faith belief that he was lying to the police. So I need to show the jurors, and the jurors need to see, to collectively understand how the police are going about this investigation and who they're dealing with and who the witnesses are that are giving sworn testimony before the court. So I believe it all comes in.
Your Honor, Mr. Steele would be assuming facts, not evidence. We don't know, because there's no evidence before this jury, because it's not relevant for this issue, whether or not Rich Homie Quan did or did not do the $25,000 for hire. There's no evidence before this court, before this jury, to impeach as to that issue.
I think they have a good faith basis to ask it.
But they don't. They can ask.
It would be one thing if they don't know that, but they do. They have a good faith basis to ask it. He's on cross-examination.
But he's not on cross. He's on direct examination right now.
But they're going to get him on cross.
If they get him on cross and they play that portion, then that's something different. But right now, for the state to play this portion, it is improper, because we have not discussed at all anything dealing with Mr. DeQuantis Lamar hiring anyone, because that is not relevant, because there's no evidence before this jury regarding those three individuals and any type of murder for hire.
I got you. Okay.
Judge might be flipping. This whole time, by the way, Miss Love has been just freaking out, shaking her head and smiling and moving around. So they come back an hour later.
Mr. Steele, however, on cross-examination, I believe it's fair game.
I done did the robbing, I done did the jacking, now I'm full rapping.
Kenneth Copeland has, we've received Brady information. He was lying to investigators for years about this, but he's acknowledged that he in fact stole from Mr. Donovan Thomas, known as Nut, stole a chain, a phone, and other belongings from Mr. Thomas at some point. Mr. Copeland also says in his statements that the Bloods, and with the approval of Donovan Thomas and another gentleman named Mo in prison, put Kenneth Copeland on the menu, meaning he was fair game to kill. The fact that Kenneth Copeland believes, whether it was through hearsay or otherwise, believes that Mr. Thomas has knocked off other people goes to Mr. Copeland's motive to commit this crime, self-preservation essentially. That he's going to get knocked off, so he preemptively shoots Nut, or Mr. Thomas, I should say. We believe that his state of mind at this time and his knowledge, or at least even if it's not firsthand knowledge, his perception, his belief Mr. Thomas is capable of ordering people's deaths is relevant in this case.
One, he has consistently said that he was not near the murder scene at the time of the murder. The phone record supports the fact that Mr. Copeland was not near the crime scene at the time of the murder. And when Mr. Copeland talks about the issues that he had during this time period, he has repeatedly said in all of the interviews that he has never had an issue with Nut. Matter of fact, he has repeatedly said that him and Nut were cool.
I mean, if you think about it, if Woody killed Nut, one of the common sense thing for him to do would be to go in there and say they're cool and they're friends, so he would never do this. To me, it looked like it was genuine. I honestly don't think Woody killed Nut.
So there's no evidence that Copeland did it, and he cannot argue that Copeland is a person who did it when there is no evidence to support that assertion.
State's clapping back, saying the defense is misconstruing everything that Woody was saying.
First of all,
I wasn't finished.
Okay.
Thank you.
Okay.
Awkward.
They're trying to bring in, again, bad character of the victim, and it's only admissible if the defendants are saying that they did it and that they were justified in doing it because they know about the specific acts that they did, which would be Muhammad v. State, which is a 2015 case, which was decided after once our new evidence rules came in regarding bad character evidence of the victim.
So Max SCHARDT is laughing right now. You know why? The state just brought up a case that Brian Steele was a part of. So now this is about to get interesting. Fanning Stillwell and Thug talking and exchanging things. What the hell? Looks like it was a headset? Earphones?
Yeah, it deals with, in the self-defense case, the Muhammad essentially says that defendant in self-defense case has to be aware of the prior, have personal knowledge or be aware of the past violent acts of the victim for it to be admissible in a self-defense case. That has nothing to do with what we're talking about here today. Because it doesn't fit this, therefore it's not admissible. We're not talking about self-defense. We're not talking about our client's knowledge of Kenneth.
Miss Love is shaking her head all day today.
The phone records show he was in a different part of Atlanta. Kenneth Copeland's statement puts him at the Green Store, which is 300 yards, 250 yards from the scene of this shooting. And we know how cell phone records or cell tower data works. And it's not the exact time, and obviously it goes by towers. Clarified and said, no, I was actually lying when I said all that, and in fact, I stole from Donovan Thomas. And the state handed that over to their credit as Brady material. So an individual says I'm not a suspect, doesn't mean they're not a suspect.
First thing regarding Mr. Copeland being charged, were the arrest warrants taken out? Yes. However, when the case came to the district attorney's office and we investigated the case, we did not indict him given the evidence that was presented before us. So Mr. Copeland has never been indicted for the murder of Donovan Thomas. They're asking you to bring in evidence of the state of mind of someone who they think killed Donovan Thomas with no evidence that that person killed Donovan Thomas.
I was the lawyer in Mr. Muhammad versus State of Georgia, and I agree with Mr. SCHARDT. It's not on point here in this issue.
Look at Miss Love's face. She cited a case and he was the lawyer.
Prosecution keeps saying that there's no evidence that Mr. Copeland killed Mr. Thomas, yet on 4 occasions on the short direct that we had already, the state asked Mr. Copeland whether he killed Mr. Thomas. The jurors don't have to accept his answer. The state has put that ball well in motion. In addition to that, to say that phone records clear Mr. Copeland, phone records are totally going to be in debate, and it's up to the jury. The state cleared Mr. Copeland, and therefore he's not, he's truly not involved in any wrongdoing is preposterous. That's again up to the jury. Saying that he killed Mr. Thomas, and the state's asking for the defense to give them the video, which I'm not going to give to them until I use it. If I choose to use it in my case on cross. I don't understand this no good faith. So with all that being said, you then go into what is the real relevance of this? And it's the same thing it's how the police did their investigation. Detective Dennis said, and I quote, "You," to Mr. Copeland, we just heard it, "You are the prime suspect, but pull yourself out of the equation." That's how we got here. That's how this prime witness got to be the prime witness. He is making up statements against Mr. Williams and others.
What we're here for is the question of fact is, did the individual charged have something to do with the murder of Donovan Thomas? What they are asking for you to bring in is Mr. Copeland talking to police about a rumor he heard in the street. Again, if they're trying to impeach him on a collateral, that's a collateral matter, and it's not allowed. And there is no evidence one way or the other, again, before this jury to even impeach him on that particular portion.
If there's a foundation for that to be asked, they can ask it. Much like the court's determination on 4, the state's not going to be required to play it in their case, but it can be played on cross-examination. Based upon what's been proffered so far by counsels for the defense, depending upon how it's if its foundation is properly laid, I'm going to say it's probably going to be able to be played for impeachment.
That's really good for the defense that they're going to be able to play that.
Investigator Dennis continues to ask Mr. Copeland about the sexual proclivities of Mr. Brian Williams, who has also been referred to as Birdman. That's the second part. And then the third part, yes, Your Honor. Investigator Dennis seems to be very interested if Mr. Jeffrey Williams is gay. And it leads to Mr. Copeland explaining that Mr. Williams is not gay, is definitely not gay, why he feels Mr. Williams is not gay, but more importantly, I'm not really interested in sexuality in and of itself.
What are we doing here, bro? What the f is this trial?
Investigator Dennis is asking, well, he wears a dress. He, wears these skinny clothes, and Mr. Copeland indicates that it's marketing. It's all about marketing, and he does these things to get attention and further his career, which we think is very relevant in this case. It's been one of the central themes that and I'm speaking on behalf of the defense here, but this has been one of the central themes of Mr. Steele's, and the state has brought in many different videos that they say show Mr. Williams doing certain things, and the response has been, well, he's instructed to do certain things. That doesn't mean that's his true self. And this is another example of Mr. Williams dressing in certain ways, doing certain things. And this isn't me saying this. I'm not the one here drawing connections between wearing a dress and sexuality and all that. Let me just be clear. That's Investigator Dennis doing that. He's saying, well, you're saying he's not gay, he's wearing a dress. And then Mr. Copeland says, well, the reason he does that is for marketing.
What defense counsel is asking to be put into evidence is not relevant. Whether or not Brian Williams may or may not be gay has no relevance to whether or not the individual charged with killing Donovan Thomas killed Donovan Thomas. There's no relevance to that. The marketing scheme or the marketing tool that Mr. Jeffrey Williams may have used in order to say he was or was not gay has no relevance to who killed Donovan Thomas. Your Honor, there's nothing about whether or not Mr. Williams was using people thinking he's gay as a marketing tool has no bearing on the trial before us.
So the judge is allowing them to ask all this shit on cross, but I would imagine the state is going to object, and I'm interested if they lay enough foundation or not.
Bloody J called Mr. Williams gay, and Mr. Williams holds a grudge because of that, and that Mr. Brian Williams is willing to sign Bloody J, but Mr. Jeffrey Williams has to give the go-ahead for that signing to happen, and essentially that Mr. Jeffrey Williams is preventing Mr. Brian Williams from signing Bloody J. But it's all based on things he's been told by the unidentified sister of Mr. Jeffrey Williams and by Bloody J, who my understanding is not testifying. So it's not based on personal knowledge by Kenneth Copeland. So that's what's discussed in that excerpt that I believe should be excluded.
We don't want that in, so we have no issue with that.
The shooting that's being discussed, I just want to be clear. I don't believe in our discovery we even received police reports about it, because I don't even think there were police reports generated about this shooting. This is kind of something that comes up and is talked about, but I don't even believe that there was police reports made.
What the? There's not even a police report of a shooting. Why are we even showing this to the jury?
Okay, but there's also the discussion about him allegedly setting up someone for robbery.
Correct.
Okay, so my objection is to all that, just so we're clear.
So I think that the state's going to exclude that.
So as you can see, it's just a lot of tedious shit today where they're figuring out what they're going to put in. Honestly, not too interesting. So I'm going to end the video here. Court's done for the week. So hopefully Monday we'll see what happens. Hit subscribe. Love you guys. Peace out.